hearing item number 14, 15, 16, and 17. If this matter may come after the winter vacation.
These are all connected ones?
Connected.
14, 15, 16, and 17.
17, Worship.
You are for the petitioner? In all cases, you are appearing for the petitioner?
Lordship, I'm for the petition.
Why? Why you need the adjournment?
Lordship, we are relying on a judgment, but the judgment is on appeal. It's fixed on 28/1 January 2026. So this writ petition will depend on that appeal.
Pending before the apex court or what?
No, Lordship, this division bench.
Oh, another matter is before the division bench.
Division bench. We are relying on the judgment passed by the single bench. However, the CGC, they have filed an appeal against that order.
Okay.
So it has been fixed on 28 January. So if this matter may come after the first week of February.
Your good name?
I, Jamir.
I, Jamir. Heard Mr. I, so all cases will be the same. Huh? Heard Mr. I, Jamir, till learned counsel for the petitioners. Is anyone comment is appearing? No.
CGC
is there, he is not appearing, no?
He was.
Okay. With the consent of the other side, he prayed for an adjournment stating that the connected appeal which has been preferred by the state respondent is fixed on 28. 1. 28 of 28?
28/1, 2026.
28/1/2026. In view of this, let the matter be listed accordingly.
First week of February.
First week of February. As on a date to be fixed by the registry. Okay.
Obliged.
May I please, my lord? Lord, I beg to mention item number 11, Lord.
Item number?
Item number 11.
Yes.
Lordship, here we are here to file affidavit with regard to the amendment petition, Lordship. So I mean,
petition has already been amended.
Lordship, by impleading the respondent, Lordship. So to that effect, we'll be filing our affidavit.
New respondents.
New respondent.
So Mr. Jamon. Vijamon, the comment? State representing the state respondent submitted that they are yet to file their affidavit in opposition against the amended petition filed by the petitioner, to which the learned counsel appearing for the petitioner, your MS?
Grace Namgi.
Raised no objection. List the matter accordingly. After 4 weeks, will do?
Lordship.
Or immediately after vacation?
Lordship.
After vacation?
After 4 weeks.
After 4 weeks, as on a date to be fixed by the registry.
Obliged.
May I please, Lordship? Lordship, I beg to mention hearing item number 12 and 13. Lordship, though it is a fixed matter, but the senior counsel R. Iralu is out of station. So kindly list the matter after.
He is out of station
vacation.
or what? He is out of station.
Yes, he is out of station.
But it was these two matters have been fixed matter, in fact.
Yes.
What do you want to submit?
I have no objection.
You are MS?
Mapini.
Heard MS Mapini, the learned counsel appearing on behalf of Mr. R. Iralu, the senior advocate, praying for an adjournment, stating that Mr. Iralu, the senior advocate, is out of station due to some personal reasons. To which the learned counsel appearing for the respondent, your good name?
CDO.
So and so, raise no objection. Prayer allowed accordingly is the matter immediately after vacation as on a date to be fixed by the registry. We are not going to give any fixed date here. Okay? You want any fixed date here? Because the date was fixed today, in fact. So you paid for an adjournment. So immediately after vacation, we are going to fix it.
Obliged.
What's obliged?
Please, my lady. I beg to mention item number 9. My lady, here I have instructions to appear for respondent number 4.
Oh,
I have
respond number
filed,
4.
yes, my lady. I have filed my Wakalatnama, but my name has not been reflected. So, and I'm here to receive a copy of the petition also. So if this matter can come up after the vacation, my lady. I have taken the consent of the
But
appellant.
it was
They are
fixed, I
not
think,
here.
it was fixed. Give me the number 8, item number 8.
Item number 9, my lady. 9.
No, no. Oh, sorry, item number 9 you are saying,
Yes, yes, yes. The MAC appeal.
no? Oh, acha, make it. What is the IA for? I is for
I was
condonation.
told that it's for condonation, but we are yet to receive a copy of the IA as well as the petition also.
Acha.
So the counsel for the appellant is not here today, but I spoke to him and he has given his consent, and he said he'll be serving us a copy soon.
You are appealing for?
Lordship, I'm appearing for respondent 1 and 3.
R1.
I filed my wakalatnama just last week, so I'm yet to receive the IA as well as the MEM petition.
The copy of the MSc appeal
Yes, the
memo
IA
you have not received
No,
yet.
not yet.
You have been not
No,
served.
we have not received a copy.
None appears on call for the applicant of the appellant. Heard MS, you are?
Miss Lucy No for respondent number 4.
So and so appearing on behalf of respondent number 4. However, she submitted that and also heard MS so and so. The land council appearing for the respondent number 1.
1 and 3, Lordship.
1 and 3. 1 and 3. However, it is submitted by the councils for the respondents that they were not provided with the copy of the appeal memo as well as the copy of the interlocutory applications. You have not filed. You have a file your wakalatnama.
I filed it last week, however, my name has not been reflected yet.
It is further submitted by Ms. So that though she filed the counsel for the respondent number 4, that though she filed a wakalatnama on the last week, but her name has not been reflected in the cause list. In view of this, the registry is hereby directed to reflect the name of MS so and so in the cause list on the next date of listing. List accordingly after 4 weeks.
For motion, item number 1.
May I please, Lordship?
So, preliminary revision.
Yes, Lordship, here I'm challenging a MP order dated 5/12/2024.
5?
5/12/2024.
5/3/24.
5/12.
5/12.
Yes, Lordship. Lordship, passed by the learned principal district in session judge.
Where is the
Denied-
order? Order you have annexed here?
Yes,
You have
Lordship.
annexed the order? Yes.
It's at page 22, Lordship.
22.
Yes, Lordship. Denied to release my vehicle on Zima.
Oh, your Jimma prayer was rejected.
Yes, Lordship. Lordship, my vehicle was seized on 14/12/2023. And it's been,
It was a case under the NDPS Act or?
yes, Lordship.
And you are also accused here in this case or no?
Lordship, along with me, four persons were arrested.
So
Along-
you are one of the accused here?
Yes, Lordship.
Acha.
And the suspected seized opium was recovered from the possession of the accused persons. And it's been under the
Who is going
custody
to
of,
appear? Union of India, is there anyone?
yes, I've served the copy to them.
No one is appearing here now.
1 and 2.
1 and 2 can be represented by only CGC or what?
Yes, Lordship. Respondent number 2 has their own special PP.
Or special people?
Yes, Lordship. I've also served the copy to them.
You are Mr.
Nsukachishi, Lordship.
And
Yes, Lordship. Nsukachishi, Lordship.
Hard MS and Kashishi, the counsel for the petition. No one has represented the state respondent side. Union of India as well as the respondent number 2. Though it is submitted by the counsel for the petition, that copy has already been served to the learned CGSC as well as the learned standing counsel for the respondent number 2. Full stop. Next, this is an application under section 438, read with section 442 of BNSS, praying for release of the seized Bolero vehicle bearing registration number MN06LA 5656, which is seized by police in connection with GR case number 816 of 2023 in under the Dimapur PS case number 03/CL/OPM/DRI/DIRU/2023-24 under section 20 small b Roman small 2 capital C/29 and 60 of the NDPS Act. It is submitted by impugn order dated 5/12/2024. The Principal District and Session Judge, Dimapur, Nagaland, in connection with IA number 876/2024, had dismissed the prayer for, rejected the prayer for Jimma filed by the present petition. Issue notice to the respondents to respondent, and also serve the copy of the petition during the course of the day, if not provided earlier. Also call for a report from the cases all charge sheeted or
Yes,
not?
Lordship, it's charged sheeted, Lordship.
It is already charge sheeted?
Yes, Lordship.
Okay, call for the TCR. Call for the TCR along with the call for the TCR. Okay, we're calling for the TCR, let us see. We're fixing it immediately after vacation.
Okay,
You want
Lordship.
any fixed date here? Better to give a fixed date, I think.
Lordship, any date, Lordship, after vacation.
Vacation is up to 14th, na? Or up to 13th. Vacation, your vacation, January 13th or January 14th?
January 13th.
14th.
Yes,
Let it be on 16th then. 16 is a Friday. 16/1, huh?
Obliged, Lordship.
For motion, item number 2.
May I please, my lord?
Yes.
Here, the applicant petitioner filed WPC number 177/2023 on 29/8/2023 before this honorable court, praying for his salary to be released with effective from 2021 till date, Your Lordship, and by order dated 24/7/2025. Your Lordship, I may take you to the relevant paragraph, page 11, para 5. Page 11, para 5. May I read, Your Lordship? It is therefore directed that the respondent number 5 shall merge the petitioner's case with the category A and forward the same to respondent number 2 expeditiously, so that clearance can be given to release the salary of the petitioner. The entire exercise shall be completed within a period of 2 months from the date of receipt of a copy of this order, Your Lordship. However, it was not considered till date, Your Lordship.
The order was of 24/7/2025.
2025, Your Lordship.
Hard URMS,
S. Jillian.
Hard MSH Jailing, the learned counsel for the petitioner. This is an application for initiating contempt proceedings under section 11 and 12 of the Contempt of Courts Act 1971, read with the Contempt of Courts Act, bracket or Gauhati High Court, bracket close, rules 1977, and read with Article 215 of the Constitution of India for willful disobedience of the court's order dated 24/7/2025, passed in WPC 177 of the 2023, whereby it was directed to the respondent. Here he is respondent. What is the respondent, his respondent number.
Respondent number 5 and to respondent number 5 is
Here,
engineer
here
in
in
chief.
respondent number.
Here in respondent number 1. Yes, Your Lordship.
Whereby the respondent number 1 oblique contemptor was directed to release the salary of the petitioner within 2 months from the date of order. Just to issue notice, list, the issue notice, epoch, and the list the matter accordingly after 4 weeks, enabling the respondent contemptor to file their affidavit in opposition, if any. List accordingly. Okay.
Your Lordship may allow me to serve copy through registered AD to respondent number 1 and 2.
Yes, issue notice or tollote লিখে দিব after issue notice through registered area and as usual process. Okay. You take steps within 2-3 days. You take steps.
Your Lordship. Oblige, my lord.
For motion, item number 3.
May I please, Your Lordship? Your Lordship, by order dated 24/7/2025, which is at page number 8 of my lecture 1,
Page number.
8, annexure 1. The relevant portion is at page number 16, paragraph 9(3). The Deputy Commissioner shall conduct a fresh inquiry after giving due opportunity to the complainants as well as the petitioners to present their case and record their statements. However, even after a lapse of more than 4 months, Your Lordship, the state respondents have not taken any action, hence this contempt petition.
So here there are 5 respondents. Huh?
Yes, Lordship.
Your good name?
And April.
Hard MS and her second name, I think. Hard MS and Rupru, the counsel for the petition. This is an application under section 12 and 13 of the Contempt of Courts Act. Contempt of Courts Act 1971, read with the Article 215 of Constitution India for initiating a contempt proceeding for the willful and deliberate violation of the court's order dated 24/7/2025, passed in WPC number 36/2022, whereby the Deputy Commissioner was directed to conduct a fresh inquiry after giving due opportunity to the present petitioners as well as complainants as well as the present petitioners to present their case and to record their statements. But even after the lapse of more than 4 months, the petitioners were not given the said opportunity and hence the present petition. Issue notice to the respondents to registered AD and as usual process. List the matter accordingly after 4 weeks, enabling the respondent contemptor to file their affidavit in opposition, if any.
Obliged, Lordship.
For motion, item number 4.
Yes.
Yes, Your Lordship. Your Lordship, the petitioner herein is aggrieved by non-compliance of the order dated 6/6/2025. Your Lordship,
25.
yes, Your
Order is
Lordship.
at page
Relevant portion is at page 41.
41.
Page 41, para 26, Your Lordship. The direction was given to the respondents to forward their family pension papers to the Accountant General Nagaland within a period of 3 months.
So till now you have not
Yes.
received any pension.
No, Your Lordship.
Yes, you are MS?
Alitosu.
Heard MS Alitosu, the counsel for the petitioner. This is an application under section 11 and 12 of the Contempts of Court Acts 1971, read with the article 215 of the Constitution of India for initiating a contempt proceeding for willful and deliberate failure to comply with the order dated 6/6/2025 passed by this court in WPC number 79/2022, whereby the respondents were directed to forward the family pension papers of the petitioner's late son to the office of the Accountant General Nagaland within 3 months. Let next issue notice to the respondents.
Your Lordship, direction was also given to the account after the forwarding of the pension papers by the respondent number 1, 2, and 3. The Accountant General shall thereafter process the family pension papers
But
expeditiously.
now you say
etc.
whether the papers were already forwarded. Do you have any instructions in that regard?
Your Lordship, there is so
Here
many.
you have, among the respondents contender, you have filed the name of the Accountant General is also there, na?
Yes, Your Lordship. There is an exchange of letters between the Director and the Accountant General as well.
Acha. Okay, then last you allowed within 3 months this, na? And respondent number 4, the was also directed to process the family. Respondent number 4 is the Accountant General.
Yes, Your Lordship.
So number 4, Accountant General was also directed to process the family pension paper expeditiously and to settle the same in accordance with law. This portion you add, huh? We'll listing it after 4 weeks.
Yes, Your Lordship.
You issue notice to the respondents contempt.
For motion, item number 5.
Yes.
Please, Your Lordship. File for complaint, questioning of a complaint, FIR. My Lord, just before Your Lordship goes into the contents of the complaint, I just point out what is of the case, it will be more better to understand. My Lord, a complainant in 2010, today is 2025, his case is 2010, he has given a loan to one Mr. Arun Bhutoria in 2010, and this Arun Bhutoria died in 2011. And in that, he said that you pay me, Arun Bhutoria said that you pay me 5 crores cash, and 5 crores cash. And 5 crores cash, we have not seen also what 5 crores cash. 5 crores cash, in lieu of that, will return that amount with a margin, profit margin of 30%, in presence of one Mr. Pradeep Agarwal. One Mr. Pradeep Agarwal. Now, subsequently, my Lord, in the complaint, they developed a story that this was also in presence of 3 directors of a company, which is one of the director is the present petitioner in the present case. Subsequently. And they said, at the time when it was given, in 2010 at Kolkata, directors were present. And all these are verbal, nothing on documentary evidence. And he tried. Some assurance was given in the meantime. 2010, nothing has been done. All in verbal, no letter, nothing. I'll show the receipt, in what manner receipt has been issued by the late Arun Bhutoria on the letterpad of this company. Now, on his letterpad. Now, my lord will kindly see, this is a complaint. In GD entry was made in summer 2023, but they said that no, please don't go ahead, some assurance was given. So that was kept in abeyance. Subsequently in 2025, this FIR has been launched. Now kindly see the FIR, my lord. FIR is at page 27. At page 29.
Yes.
Now, Lordship will kindly say, see the second, the accused person or as under. Number 2 is a petitioner, present petitioner before this court. Number 2, the aforesaid accused person are the owners, controllers of a company, namely Messrs. Epcon Properties Private Limited, having a place of business at 4th floor, flat number so and so. Now, this is the case, guys. On 10/12/2010, so Arun Bhutoria, now deceased, was introduced to me by Pradeep Agarwal, son of late so and so, who has been known to me for many years. The meeting was held at Dimapur, Nagaland, which is under the jurisdiction of your PS. See, Arun Bhutoria, deceased, represented to me, which represented subsequently transferred to be false and dishonest, that their business was in very good financial health, but that he required a long-term cash accommodation in the form of a loan in goodwill and promised to pay a profit of 30% on loan amount. My lord, if this paragraph is to be looked into it, my lord, is very clear that it cannot be a case of neither 409, cannot be 120, it can be a commercial transaction. Supreme Court has held in 2019 also. I'll show one judgment, clear-cut judgment is there. It's totally a commercial transaction. If you indicate a profit of 30% with a promise to return the amount, it cannot be a cheating. 2010 and 2025 they lost the FIR because the limitation also goes. They know very well. Now kindly see the second paragraph. At the relevant time, he malafidely suppressed the true financial health of his companies and sought a long-term loan or rupees 5 crores only for a period of 4 years. Relying upon such assurances, I so and so under say handed a sum of rupees 1 crores only in cash on the same date, and I agreed to give a further sum of rupees 4 crores on 17/12/2010. Subsequently, in furtherance of my earlier assurance, on 10/12/2010, a sum of rupees 4 crores in cash was given on 17/12/2010 by me to Arun Bhutoria in his office in presence of Sri Pradeep Agarwal and 3 other directors of Epcon, namely accused number 1, 2 and 3, who also assured and promised to repay the same to me in 4 years. Receipt of money is annexed herewith. Now for a moment kindly see the receipt. Then I will see the receipt as page 54. 53 is in his letterpad. Kindly see, my lord, 53. Top, kindly see in his letterpad, Arun Kumar Bhutoria, Lordship got it. Letterpad. Now, see at 54, type copy. Received a sum of rupees 1 crore in cash on 10/12/2010 at Dimapur. Amount of 4 crores in cash at Kolkata from so in presence of Pradeep Agarwal. A total amount of 5 crores cash with a profit of 30% shall be positively returned within a period of 4 years, not later than 10/12/2014. Witness so and so for Epcon. So this is his letter pad personnel, and you are involving this present petition and all two directors. He was not even a director at this company. Kindly see, my lord, he was not a director. At page 55, kindly see. See 55, he was not a director also. And 5 crores in cash, kindly see at page 55, the Ministry of Corporate Affairs. Now see the next page. Last entry, kindly see, my lord. Last entry, so and so, director, and say date of situation 24/11/2010. Kindly see on the last entry 18. This is my lord, Ministry of Corporate, so and so Epcon Properties, director designation. Kindly see date of situation applicable. Kindly see on the right hand down below 24/11/2010. He was not a director also at that company. His own personal capacity, he has taken a loan of 5 crores. Arun Bhattacharya, he is no more, he is dead in 2011. You could not realize that amount. Now you are dragging all this person. Now kindly see the next paragraph, my lord. Now again at page 30. See page 30, my lord. We were reading third paragraph, fourth paragraph. See page 34th paragraph, my lord. Subsequently, in furtherance of my earlier assurance on 10/12/2010, a sum of rupees 4 crores in cash was given on 17/12/2010 by me to see Arun Bhattacharya in his office in presence of Sri Pradeep Agarwal and 3 other directors of EPCON, namely accused number 1, 2, 3, who also assured and promised to repay the same to me in 4 years receipt of money. In and around September, now he is now building up a case. In and around 2015, I requested the accused to account for and return the sum of rupees 5 crores along with profit, and also immediately sought the intervention of Sri Pradeep Agarwal. After weeks of persuasion request, accused person sought time to clear the liability, citing reason that the father of accused number recently expired, and they thus requested for some time. No documentary evidence, my lord, to show that letter was issued, some promise was made, nothing was there to any of the directors. Now kindly see next. In or around December 2016, I again requested accused for return the loan to me along with profit, and once again sought the intervention of Sri Pradeep Agarwal. Accused person collectively assured me that the company project has been sanctioned and that by 2020-21 the project would be completed. Further, all dues would be cleared after that a copy of sanction pen is annexed here. In mid-2022, I once again approached the accused person for repayment of the loan amount along with profit. Accused person kept delaying the matter with one's excuse or another, and by December 2022, it became apparent to me that the accused person had no intention of repaying the sum due to me. I am aware that this accused person had defrauded many other persons in this manner. They are a threat to society and commerce. A thorough investigation that required to unearth the nature and extent of criminal conspiracy hatched by them. I am a private person and I know resources to gather the unnecessary evidence to prosecute the accused person. Meanwhile, the interrogation is promptly required to catch the modus operandi of the illegal activities. False and dishonest inducements are made at so and so, which is situated on the area of a police station. Therefore, I request you to kindly treat this as a FIR and investigate the officer. So this is the case, my lord. And my lord, what has happened? Now a notice, they said a notice was given at page 34, under 35 of BNSS. There is no notice we have received. Kindly see. And he was not in India also. Where is the question of receiving any notice under BNSS? Page 34. Kindly see, these said that 35, 3 BNSS has been issued on 2 different dates. My lord, all these are technicality. Yes, if no BNSS, automatically you all also knows that there is a judgment. They said that some notice was sent. We flatly refuse that there is no notice which has been issued. Now, before the learned CGM, they prayed for issuance of a non-bailable warrant. Once the police notice, they said, was not received, an application was moved before the learned CGM at page 36. Kindly see, my lord. Prayer for issuance of non-bailable warrant, so and so. Same story, my lord, first paragraph, second paragraph, third. Now, now see the examination of a complaint, third paragraph. The complainant was thoroughly examined and stated that he is a businessman and a politician. And a politician by the year 2004-2005. He became acquainted with Mr. Pradeep Agarwal. So and so, through mutual friend, as they were both engaged in business. In the year 2010, Mr. Pradeep Agarwal informed him about a business proposition in real estate at Kolkata, which could yield profit. On 10/12/2010, at so and so, he was introduced by Pradeep Agarwal to Mr. Arun Bhutoria, who represented himself as one of the director of so and so. Arun Bhutoria proposed that if he invested in the company for a period of 3 to 4 years, company would return the invested amount with 30% profit. Though initially spectacle on the assurance of Pradeep Agarwal and Mr. Arun Bhutoria about the company's financial soundness, he agreed to invest. Accordingly, on 10/12/2010, he handed over 1 crore in cash, and thereafter on 17/12/2010 at the office, so and so he handed over 4 crores in cash to Arun Bhutoria in presence of Pradeep Agarwal and other directors of the company of so and so. All directors assured repayment of so and so along with 30% interest within 4 years. Arun Bhutoria issued and signed a money receipt acknowledging the total amount, which was also signed by Mr. Pradeep Agarwal as a witness. Now, this Pradeep Agarwal, my lord, he said that in presence of Pradeep Agarwal it has happened. And Pradeep Agarwal is same, he said, in presence of Pradeep Agarwal, other directors. Now, this Pradeep Agarwal is not made as an accused in this case. Because I have seen the statement of these two Bhutorias, the other two directors, where they indicated that there is some dispute with one Pradeep Agarwal. They have stated in that. Now kindly see, all the directors assured so and so. Yes. All the directors assured, but these directors never signed. My lord, there is, suppose A has given a loan to me. I have accepted loan. Now there is some 2-3% is there. They said no. They are also present. They assured, said yes, okay, he'll pay it. And ultimately, end of the day, I died, then these 2%, said, the complainant says no, they are also liable for that. This is what the case has been made out. This is absolutely a case has been made out. Whether my lord will kindly see, without going into all this statement, on the face of the complaint, my lord A gives a loan to B, B, my lord, died, with an assurance that he will pay the amount, with an interest profit of 30%, he doesn't pay it. What is an alternative? Is this a case of cheating? Is this a case of a criminal breach of trust? Which they said it 409. 409, your lordship, no definition of 405. Some domain over a property, which is given, I have a domain over the property. I have misused and used that property for some other purpose. That only a person will be liable. How can some third party who has not signed, nobody is there, it is a total a loan is given, how he is, my lord, entangled in all these cases? A domain over a property, and what is 409, your lordship, no, 409 is a public servant, is an agent, is a broker, how it is attracted in this case? And 120B, your lordship knows 420 definition is 415. There has to be initial deception. Initial deception by whom? At best, it can be attracted only to Arun Bhutoria, who is no more. And Mr. Pradeep Agarwal, in presence of a witness, we were not a part of it. This is how he has been dragged. And two of the directors, I will tell you, lordship, two of the directors he has been picked up. This petitioner has not been picked up. Two directors has been picked up from Delhi, and Your lordship knows the order is that a transit, he has to produce before a court on transit. That has also not been done. Directly has been picked up. This is the situation, my lord. I will not trouble much, my lord, with those statements. Your lordship has to examine all this. And last page, your lordship knows that they also know that there is no case, and ultimately non-bailable one was, kindly see this, my lord. Page 57, kindly see. NBW was cancelled against this person at page 57. The court also realized, my lord, ultimately. See at page 57. See page 57, receive report, so and so, Milan Shah, so and so, peruse the report, satisfied. Accordingly, issued against the aforesaid accused is hereby cancelled and withdrawn. Court also realized that this is what has happened. Unless he has been dragged, NBW has been issued. Our lawyer goes there, plays the facts, it has been cancelled and withdrawn. Kindly see. See are put up. Kindly see, my lord. They know, my lord, nothing is there against this person. You are unnecessary, you are harassing this person. And my lord, so tragic. This petitioner, daughter stays in US. The daughter has given a baby miscarriage and died. He went there. He was there. Your lordship, these are all mental trauma. He has gone to his daughter's place, and this type of situation.
The 35A notice was issued to you.
Yeah, it is not. We have not received any notice. He was in US. How can it be received? We can't receive the 35 notice also. We have stated, we have given the ticket also. Kindly see. At page, kindly see my ticket, flight ticket, my lord. How they can say that I have received this notice? Air ticket is at page 42. Kindly see 42. See 42, my lord. See. See at page 42, I purchased my ticket, kindly see 18th of August 2025. And 5/9 issued, and I purchased on 18 August, kindly see 2025. Miscarriage on 17/8, and I have annexed. Page 32, kindly see, my lord. Page 32. Kindly see page 32. My daughter's particular. Page 32. These are, my lord, fatal demise. Kindly see. These are at a moment where I don't receive any notice. You do it. These are trend going on, my lord. When you don't realize it, a short circuit matter had been used, and my criminal proceeding has been an FIR lodged. 2010 and 2025. Kindly see. I'll show an exact judgment of the Supreme Court, my lord. Kindly see. And notice has been issued from here. Kindly see the judgment of the Supreme Court, how it has been dealt, my lord. One judgment, there are other judgments, latest, Honorable Chief Justice, how it has been used, misused, all the powers. If your lordship wants something factual, I can tell your lordship. Anything factual, your lordship, I can say. My lord, 2019, 9 SCC, kindly see paragraph 11. I think this is one of the fittest case. Kindly see para 11. Having observed the background principle applicable herein, we need to consider the individual charges against the appellant. Turning to section 405, read with section 406, we observe dispute arises out of a loan transaction between the parties. It falls from record. Respondent number knew the appellant and that attendant circumstance before lending the loan. Further, it is an admitted fact, in order to recover the aforesaid amount, Respondent number 2 has instituted a summary civil suit which is still pending. The law clearly recognizes a difference between simple payment, investment of money, and entrustment of money or property. That's what I said, my lord. You have given a money for the purpose of investment with a profit of 30%. It is not a case where, my lord, entrustment of money. It is for purpose of investment. A bare breach of promise, agreement, or contract does not ipso facto constitute the offense of criminal breach of trust contained in section 405 without there being a clear case of entrustment. In this context, we may note there is nothing either in the complaint or in any material before us pointing to the fact that any property was entrusted to the appellant at all, which he dishonestly converted for his own use so as to satisfy the ingredients section 405, punishable under section 405. Hence, the learned may say committed a serious error in issuing so and so against the appellant for this said offense. Unfortunately, the High Court also failed to correct the manifest error. My lord, here is a case. If late Arun Bhattaria would have been approached before the court, it would have been a very good case for him. We are not, for us, my lord, we are like a stranger. Even I am arguing for who is no more Arun Bhattaria. My lord, it can be, if it is Arun Bhattaria, he had a case. Forget about all the present petitioner. Present petitioner has not been involved. Now, he doesn't know this person, my lord. It is a pure transaction between Arun Bhattaria, the complainant, and in presence of Pradip Agarwal. Kindly see the 13. Now coming to the charge under section 415. Punishable under section 420, in this context of contract, the distinction between mere breach of contract and cheating would depend upon the fraudulent inducement and mens rea. In the case before us, admittedly the appellant was trapped in economic crisis and therefore he has approached respondent number 2 to ameliorate the situation of crisis. Further, in order to recover the aforesaid amount, respondent number here no suit has been instituted. Has instituted a summary civil suit seeking recovery of a loan amount which is still pending. The mere inability of the appellant to return the loan amount cannot give a rise to a criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction, as it is this mens rea which is the crux of the offense. If it is a loan with a promise to return, there cannot be any mens rea. Even if all the facts in the complaint and materials are taken on their face value, no such dishonest representation or inducement could be found or inferred. Now, my lord will kindly see the last paragraph at 17. In view of the above, we are unable to uphold the impugned order passed by High Court in so and so, and the same year is set aside. Application for the application under section 482 is allowed. Proceeding initiated based on the FIR instituted as an hereby quashed. I think this is one of the most fitted case. My lord, there are other cases I don't know trouble now at this stage, my lord. I just pray that notice may be issued in this case. And in the meantime, quote the petitioner, this is absolutely out and out is an abuse. It should be stayed so far as the quote the petitioner is concerned. That is my humble prayer. Your lordship has seen that on the face of it, no case. I don't know this person. He claims that he has stated in his complaint that this money was given to so and so in presence of Pradip Agarwal, promised to return the amount. My lord, what the Supreme Court has said? Where is the question of dishonest intention here? That's my humble submission. Notice will be issued in this case, my lord.
Yes.
I'll accept notice.
You keep a copy also if you want.
No, I am going to accept a notice. And there is another prayer from the other side. Stay of the investigation in respect of the present petition. In that regard, do you want to submit anything?
Lordship,
Because case is still at the stage of investigation,
Lordship.
not yet charge sheeted. So in that
Since
case,
notice has been issued under section 35(3), witnesses to the petitioner lordship, and they have not appeared till their lordship.
they have not cooperated.
Lordship. So lordship, as far as stay is concerned, lordship, on the next attainable date, Lordship, since I have to take a necessary instruction.
But as per 35(3), what was the date for your appearance before the court?
Yes, I'll tell your lordship. My
That
appearance,
was issued on 14th.
my lord, it was issued on 1410.
1410.
Kindly see my lord appearance, 1410. It was issued on 14/10/2025 at page 34,
Directing you to appear.
directing to appear on 5/9. Yes, okay, no. All relevant documents relate to on 5/9 and 9/10.
No, no, how it can be? 5/10 and?
5/9.
No,
If
no,
you see
issued on 14/10.
14/10.
You were directed to appear on which date?
1410, he said 31/10. 31/10.
31/10.
Lordship, 11.
31/10. 31/10. And how, my lord, apparently I am not in India also. Your lordship has seen tickets, kindly see, my lord. I am not in India.
No, no, suppose that during that period you were not in India, but now at present your location is in, now is in India.
No, he is not in India. He is abroad, my lord.
No, no, now, presently.
No, presently he is not here, my lord. Wakalatnama, kindly see. Postal Wakalatnama from US. That's the whole problem, my
What
lord.
happen here, it's okay, but the question is that 35(3) you have to
Lordship.
appear
Lordship.
under the obliging detail.
No, there is absolutely no problem, my lord. There is
So
absolutely
do
no
you want
problem.
any thing that you are in abroad? I can understand.
Yes.
But your cooperation on the basis of 35(3), because the warrant of arrest has already
none-
been withdrawn against you, that is,
Yes.
you have submitted and the
Yes.
court had already passed the order.
Yes.
Now the question of 35(3).
Yes.
So 35(3) is your any kind of, can you
Can you-
appear within month of January,
Now, what can be
February?
done? Yes, what can be done? Your lordship will issue a notice. No coercive measure against this petitioner. No coercive. 1, 2. Number 3, if they want, you can buy virtual, because there is always a link that can be given. Link. Virtual
See,
after.
35(3) means you were also directed to produce any documents there?
Documents, all
Yes.
those documents.
So these are things.
No, the documents are only 35(3) is.
35(3) was there.
Yes, 35. 35 is only has been given. No documents, nothing. Nothing 94. 94 has not been served. What can be done, my lord? No coercive measure against this petitioner. In the meantime, I will cooperate whenever he comes. But in the meantime, if they want, I can give the virtual thing and they can talk. It is always provided nowadays. Your lordship knows. From jail also provision, that provision is there.
Lordship, but virtually it's become difficult, Lordship. So,
I can
Lordship,
understand that is a bit difficult. A bit difficult to interrogate, to questionnaires and all.
Lordship.
But still provision is there, and I'll pass the order anyway. Heard Mr. Dita, still on senior advocate, assisted by IDAS, still learned counsel for the petitioners, and also heard Mr. B. Jomo, the learned PP of the state of Nagaland for the state respondent. This is an application under section 528 BNSS corresponding to section 482 CRPC, paying for quashing of the FIR dated 11/10/2025, which is registered as Dimapur Suburban Police Station case number 56/2025 under section 409, 420, 120B, 120B, that means of IPC. It is submitted by Mr. Das, the learned senior advocate, that the case of the present petitioner was initiated with the transaction of money in the year 2010 with one Arun Batoria. 2010 with one Arun Batoria who died in 2011, wherein there was a transaction of 5 crores, and as per the statement made in the FIR, all the transactions were in cash, and the present complainant oblique the informant was assured to give 30% of the profit for the said amount of loan, on the said amount of loan. Thus, it is purely a commercial transaction, and it is not a case for any entrustment of property or the simple entrustment of money or of the property. Rather, it is a commercial transaction wherein it was promised to pay 30% profit to the present complainant. But from the letter paid and from the money receipt which was given in a letter paid of the complainant, it reveals that the entire transaction was completed in presence of one Pradeep Agarwal, and in the said letter paid there is no mention at all about the presence of the petitioner, who is stated to be one of the directors of the company, namely, what is the company?
Epcon.
Epcon. But during that period of time, the present petitioner was not even a director of the said company.
The present,
Sorry.
no, not been, Arun Baturia.
Sorry,
Late Arun Baturia.
Said Arun Baturia was not a director of the said company at the time of the transaction of money, and what has been done was purely on personal, it was purely a personal transaction. Full stop. The petitioner's name was not even in the, he was not even present at the time of the transaction, but only to only for procuring the money. The present petitioner along with two directors' name has been mentioned in the FIR. The entire transaction was completed in the year 2010, but after a long 15 years, the present FIR has been launched only in the year 2025. Full stop. Next point. He further submitted that
These are oral only, no evidentiary document in this.
Yes, submitted that though as per the
FIR is registered in the year 2023.
2023. It's not 25.
GD entry 2023.
আচ্ছা
2000 GD entry they kept in abeyance, so 2025.
আচ্ছা সেটা লাইনটা অকমান চেঞ্জ করে দিব. Submitted that in the year 2023, that is after 13 years, one GD entry was made, but it was kept in abeyance, saying that some assurance was given from the accused person, and subsequently the FIR has been registered only in the year 2025. Further, Mr. Das, the learned senior advocate, submitted that these are all the oral submission from the informant, but there is no documents, there is no documentary evidence.
Except the money, except the receipt.
And no documentary evidence except the money receipt to substantiate the plea of the complainant that the transaction was completed in presence of the petitioner, who is one of the director of the company, namely Epcon. Next, further it is submitted that as per one notice under section 35(3) BNSS was stated to be issued on 1410.
1410, 13, yes, 1410
1410/2025
to appear on
directing
3110.
the present petitioner to appear before the investigating officer on 3110/2025, but the present petitioner never received the notice under section 35(3) BNSS, as he was in US and he is still in US.
Yes, yes.
As he is presently in US after the miscarriage of his after the miscarriage of his daughter, and since August 2025 he is in US. First. But without even receiving the notice, an order of issuance of NBW was procured by the investigating officer, but subsequently, that by order dated 2/12/2025, the learned magistrate had withdrawn that NBWA which was issued earlier against the present petition. Further, citing the judgment of Honorable Supreme Court, reported in 2019 9 SCC page 148, it is submitted by Mr. Das that there is no ingredients to attract neither section 406 nor 401 as registered against the present petitioner, and and law clearly recognizes a difference between simple payment, investment of money, and entrustment of money or property. But here in the instant case, it is seen from the complaint filed by we have seen from the FI itself that it was purely a commercial transaction wherein the profit, wherein he was assured to give 30% profit by late Arun Baturia. Thus, there is no case, there is no ingredients to fulfill. There is no evidence. No, there is no ingredients to fulfill the. There cannot be any case against the present petitioner under section 406 of the 409 IPC. Next para, however, it is submitted by Mr. Das that the present petitioner is still ready to cooperate with the IO in compliance of section 35(3) BNSS, and he may be interrogated through virtually as he is in US presently, as he is presently staying in US. Mr. Das further submitted that no coercive action no coercive action shall be taken against, may not be taken against the present petitioner as he is ready to extend his cooperation. Next part. Mr. Jammu, the learned PP, Nagaland, state of Nagaland, has submitted that the case is still under investigation and his interrogation and his presence is required, for which the 35(3) BNSS had already been issued against the present petition. But in spite of receipt of the notice issued to him, the petitioner is not cooperating with the IO, and he is not cooperating with the IO, and hence his physical presence may be required for the interest of the investigation. Next part, considering the entire submission made by learned counsel for both sides, made in the case record, which has been and also after perusal of the annexures filed along with the petition, the investigating officer is hereby directed not to take any coercive action against the present petitioner. However, the petitioner is hereby directed to extend his cooperation in the investigation of the IO, to extend his cooperation in the further investigation of this case, and his statement may be recorded if he However, till his return from US, he may be interrogated or his statement may be recorded by investigating officer to virtual mode. But when is a probability, any probability?
Maybe by January last, maybe, because we don't know exact, January last maybe.
However, the
Or January,
police will,
February.
the investigating officer will also make inquiry in compliance of section notice under section 35(3) BNSS after his physical presence before the investigating officer, preferably within the first week of February. You want to submit the case diary and all, no? Call for the, in the meantime, call for the scanned copy of the case diary. Let the matter be accordingly listed. Let it be listed on mid of February if suppose the interrogation is there.
In the meantime, extra copy may be sent.
Yes.
I'll appear for respondent.
Notice to দিব notice issue notice করি notice has already been একদিন মাই দিব তাতে মিলাই দিব notice to issue করে দিলে হয় mid of February I'm supposing that 12th of February may be
My
given,
lord,
I
what
think.
we can do it, because this goes very long, doesn't look nice also, so long. So let it, because by that time, if he comes well and good, if he gives only statement, recorded virtual, then any matter. So let it come after reopening of the court. That's, I think, that's otherwise it doesn't. 16th of January.
Let the matter be
Otherwise,
listed according to
February.
16th of January. Okay, we're listing on 16th of January. In the meantime, suppose if his statement or inquiry can be completed through virtual mode, it's okay.
Yes.
And then you get updated case diary along with everything, so that the order can be.
My statement also can be recorded through virtual if necessary. Yes,
I
that's all. That's right, ma'am. That's right. We'll cooperate. There is absolutely no problem. Yes.
Cooperate
But-
with the
but-
IO because prima facie it really seems that
I
obviously it
also-
was a commercial transaction.
But
with some
I also
material.
feel, after looking it is a commercial, after looking it, we complain. Subject to what my learned friend with a case there, he comes up altogether.
Otherwise, prima facie or apparently it seems maybe a commercial transaction because question of profit is there. Because assurance was there that he will be given 30% of the profit. So that may be one of the aspect. Otherwise, let's see what happens. We're fixing it on 16.
5 crores cash, my lord.
And
That's what
we never.
that is also troubling. 5 crores, 1 crores and 5 crores, 4 crores goes to Calcutta, takes the huge cash and pays. That's also a bit of
4 crores, 5 crores in a cash, a bit.
no agreement, nothing, only money received. That's it.
And how can a person give 5 crores cash only on the verbal assurance of giving 30%? That was in the letter paid only.
Yes,
notice was
later
there.
paid, yes. I am deeply obliged, man. Yes, I see. Deeply obliged.
For motion, item number 6.
Your Lordship,
Yes.
Please, Lordship, the petitioner is aggrieved by non-compliance of court order dated 8/5/25 passed in WPC 143 of
8/5/2025.
8/5/2025.
Where is the order? Have you annexed the order here?
Annexure G, page 18.
Page 18.
Yes, Your Lordship.
Yes, the operative part is at
Page 20, para 7.
page 20. So state respondents were directed to consider the case of the petitioner.
Yes, Your Lordship.
So he was doing for compassionate appointment.
Yes, Your Lordship.
The order was passed on 8/5/2025.
8/5/2025. Your Lordship, para 8.
So within 6 months it was there.
Yes, Your Lordship.
6,
It is
7,
already
8,
lapsed, Your
9,
Lordship.
10, 11. lapse.
Yes, Your Lordship.
You are MS?
Alitosu.
Hard MS Ikiba, so and so, the learned counsel for the petitioner. This is an application under section 11 and 12 of the Contempt of Courts Act of 1971, read with the article 215 of the Constitution of India for initiation of the contempt proceeding for the willful and deliberate failure to comply with the order of this court dated 8/5/2025, passed in WPC 143/2024, whereby the respondent contemner was directed to consider the application of the present petitioner for appointment on compassionate ground against one of the 24 vacancies in which department it is?
Home Commissioner.
Oh no,
Home Department, Your Lordship.
24 vacancy in the concerned department. Issue notice to registered AD. List the matter accordingly after 4 weeks, enabling the respondent contemner to file their affidavit, his affidavit in opposition, if any. Here we have made only one, this by name.
Yes, Your Lordship.
He was the Home Commissioner at that time.
Yes.
He is still here as a Home Commissioner.
Yes, Your Lordship. Much obliged.
List accordingly.
For motion, item number 7.
None appears, no? None appears on call for the petitioner applicant. List the matter accordingly after vacation.
Please, Your Lordship. Lordship, first of all, I apologize for interrupting the court this way. But I have one urgent matter to be listed. I'm mentioning for listing of the matter on Friday, Lordship.
What kind of matter?
It's a read petition. I was under the impression that Court 1 will sit after the TV, but today the single bench is not available for Court 1. So I have to mention before Your Lordship.
Friday not possible. Friday not possible.
Friday is the last court.
Not possible. For this court, I cannot.
I think it will be listed before the Court 1, but mention I have to make it here. Because today the Court 1 is not in session. Only the DP is available. The single bench is not
Whether the
available.
process.
It's a single bench matter.
Huh?
It's
No,
a single
yes,
bench
yes.
matter.
Can it be? Because Friday.
Urgency is there, Lordship. Because Friday is the last court and there is a limitation.
Not at all possible Friday.
Our problem is limitation is there.
Friday not possible.
Possibly it might be listed before the Court 1 only in the senior
That
bench.
I don't know, but Friday not possible, may not be possible. Yes, Mr. What to do?
Let us try our luck.
No, we are not in a position to pass the order, that's what. Friday not possible now. Huh? Tomorrow I have fixed another lots of matters by myself also. Tomorrow is not possible. No, I'm saying what I'm saying. If I suppose prayer, they allow the mention prayer also. It may be listed in court number 1 or 3 also. Or whether the probability if this is here, though there will be a problem. We are not in a position to pass any order. But how can we say now? Huh? Not possible.
Lordship, actually I have filed it on date 3 only last week.
Then why you're waiting? Could
No, the
make a mention
filing
here.
section is not passing the file.
No, you could have mentioned here.
That is why I'm
Monday,
mentioning
Wednesday,
today.
Tuesday, we could
I
have.
filed it on
raised
Wednesday
today
and then
itself, it could have been, listed.
I was not the station counsel. I came from
That
Gauhati.
what can we do?
I have
Friday
filed
not
it and
possible
they say
for
that
us also, no?
it will take time for them to entry because there is a lot of list of petitioners. The petitioners are 919 list. So they say they will need some time. So that is why we have waited for the call. But since no positive response has come, I've come today. Lordship may kindly give us opportunity to try our luck.
No, we are not in a position to pass the order.
It is a motion matter, so it might come in court number 1 also.
That I cannot say now.
Probably, if the DP is not available on Friday.
কি কৰিব পাৰিব?
But this is a senior bench, I have to mention here only, no? If it is a new motion.
Okay.
Deeply, man, deeply.
For admission, item number 2.
Item number? Admission. This is yesterday's matter, na?
Yes, my lord. Day
Yes.
before yesterday's matter, my
So
lord.
it has come, your
I am told the
scan copy, case diary,
Lordship.
the trial court record has come already.
Lordship.
Yes,
Here
what is your
a-
submission here?
And then a trial court record. This is a seal.
Huh. Hey, Kunokson? Then put up that mentioned matter before this court. তাতে আপুনি কৈ দিব মোৰ আৰ্জেঞ্চি আছে মই অলপমান গৈ কালি গৈ কিবা এটা বস্তু এটেণ্ড কৰিব লাগিব ইম্পৰ্টেণ্ট গতিকে মই ইয়াতে 2টা 3টালৈকে থাকিব নোৱাৰোঁ চ' আস্ক দি বেঞ্চ পিপল to hear আৰু asked the bench also to register very less numbers of matters so that I can cover it everything latest by 11:30 or 12 so that I can leave. So more calm urgent. So make me listed before report number 3. Yes. So yesterday you have mentioned that he was arrested. There
Yes,
was
my
no
lord.
recovery.
yes, my
One.
lord. Yes.
And
Secondly, the warrant.
originally subsequent charge sheet he was
Yes,
named.
my lord. Yes.
And on the basis of the statement of the co-accused, he got
My lord.
arrested in this case.
The chart,
And,
the NPWA, the non-payable warrant of arrest.
Non-valuable warrant was also not read over to him.
Yes, my lord.
Yes. Any further?
Yes, my lord. And in the section 48 document, that is the information to the family members or the relatives or the wife, children, there is no signature, lordship. Because, lordship, the arrest was made at Kangkokpi district at Manipur. And the section 48 document, it was issued from Tseminyu district at Nagaland, my lord. Now, and lordship, in bail application 21 of 2025, lordship, this honorable court has held that the signature, because lordship, these days, now the police have also become wise, my lord. And they are placing documents, lordship, without any date, seal or signature, saying that we have served the grounds of arrest, information has been given in writing to the family members, but there is no acknowledgement, no receipt, nothing as such, which is why this honorable court has held that the signature of the wife or relative to whom the police, the arresting authority, is claiming to have served the grounds of arrest of the accused, that must be present. And without that, the court hold that no, section 48 has not been complied. If I may be allowed to place this, it's a very short paragraph. Itu wala. I have marked the 11th page, my lord. Page 4, paragraph 7, my lord.
Paragraph 7.
Yes, my lord. This court has given due consideration to the submission of the learned counsels and have perused the case diary which is produced by the learned public prosecutor. Upon going through the case diary, it is seen that as far as the accused is concerned, the arrest memo, rights of arrested person, grounds of arrest, right to bail, and all other requirements have been communicated to the accused person in writing and also read out and explained to him in the language he understands. That means Section 47 has been complied. However, as far as the wife of the accused is concerned, there is only a remark that intimation of arrest was given to the wife under Section 48 BNSS. There is nothing to show from the records that the ground of arrest was intimated in writing to the wife, also which is a mandate of Article 22 of the Constitution. It is the requirement of law that the grounds of arrest have to be intimated to the relative/friends or such other persons as disclosed or nominated by the arrested person for the purpose of giving such information according to Section 48 BNSS. It is also a requirement of law that such grounds of arrest in writing have to be acknowledged and signed by the wife/relative, and the same has to be on record. This court is unable to find any such record of receipt of the grounds of arrest from the wife/relative of the arrested person. In view of the above observations and discussions, this court is of the view that the requirement of Section 48 BNSS and the mandate of Article 22, subclause 1 of the Constitution has been violated in the present case. Accordingly, the petition is allowed. My Lord, if my Lord will kindly go to page 66, Lordship. Page 66 of my bail application, my Lord. Yes. Annexure 14, my Lord. Page 66. As my Lord can see, in the police station and district, it is Jeminyu. This is a district in Nagaland, adjacent to the next district to Kohima, my Lord. Earlier, this district was also part of Kohima, but later on, it has been bifurcated. Now, my Lord, there is no seal, no date, no time, my Lord, and no acknowledgement from the person the police are claiming to have served the grounds of arrest. So, the law laid down in Bail Application 21, my Lord, squarely covers my case. Now, my Lord, secondly, on the ground of not reading of the warrant, I may be allowed to place 2025 SCC online SC 1228. Paragraph 36, my Lord.
36.
Yes, my Lord. It is the last second page of the. Yes. I'll read only a single sentence, the first sentence from paragraph 36. If a person is arrested on a warrant, like the present accused, my Lord, the ground of arrest for the arrest is the warrant itself, my Lord. Now this comes with a rider, my Lord. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed of the grounds for his arrest, my Lord. Now, in my case, this, if it was read over, the requirements under Section 47 would have been discharged, my Lord. But it was not discharged, my Lord, because the warrant was not read over to me, Lordship. And in fact, it was only after he was, long time after he was arrested, through the councils only, my Lord, we were able to obtain the warrant also from the trial court records, my Lord. And, my Lord.
What warrant?
The arrest warrant, my Lord.
Arrest warrant was?
Obtained, Lordship.
From the trial court.
Yes, my Lord. It was not served to us. Now, my Lord, again, page 68, Annexure 15, this is the non-bailable warrant of arrest. Now, since, my Lord, the law is that the warrant of arrest is a substitute of the ground of arrest under Section 47. That means, my Lord, the gist of the offense, at least the sections on which I am being charged with, I am being arrested, my lord, or the act, it must be mentioned, lordship. Now, Annexure 15, my lord, page 68. Nowhere, lordship, in the entire document, no section, lordship, the act is also not mentioned. That means, my lord, the requirements under section 47 or, my lord, under Article 22, subclause 1 of the Constitution of India has not been discharged, my lord. Earlier, my lord, I have approached this honorable court because, lordship, the two accused who were actually caught with those contraband substances, they have already been enlarged on bail by the trial court. So, claiming parity, I have approached both the trial court as well as this honorable court. But unfortunately, my lord, the court rejected my bail applications, saying that, no, the law of parity cannot be applied here, my lord. Despite the fact that nothing was caught, nothing was seized from my possession. Therefore, my lord, there is clear violations of section 47, 48, read with Article 22, subclause 1 of the Constitution of India, my lord. And even on merits, my lord, since nothing was recovered from me, even assuming that there is no 47, 48, 22, 1 of the Constitution of India, even then, even on merits, my lord, I am entitled to bail because I think it will be a Herculean achievement if the prosecution will be able to convict me in this case, my lord.
Let's see.
And like, now the law is well settled, lordship, that statement of co-accused is not admissible in evidence. Of course, my lord is well aware, but I would like to place a single citation, a very short paragraph, lordship. 2024 SCC Online, 3803. Para 12, my lord. As noted herein above, the sole material available against the appellant is the confession statement of the co-accused, viz. Accused number 1, which undoubtedly cannot translate into admissible evidence at the stage of trial and against the appellant. When that be the position, how can it be said that the prima facie case is made out to make the appellant to stand the trial? There can be no doubt with respect to the position that standing the trial is an ordeal, and therefore in a case where there is no material at all, which could be translated into evidence at the trial stage, it could be a miscarriage of justice to make the person concerned to stand the trial. Here, lordship.
What kind of petition this is, quashing or what?
Yes, yes, my lord. Here, but the principle, my lord, is that the statement of the co-accused, lordship, is not admissible in evidence, my lord. That is
The statement of the co-accused may not be admissible, which is recorded under 67.
My lord.
May not be admissible at the time of trial.
My lord.
But what the police will do at the time of investigation,
My
you
lord.
see, the question is a bit different because at the time of investigation, police requires something
Yes, my lord.
to nab the person or to
My lord,
investigate.
my
So,
lord, my lord.
basis of the co-accused statement, maybe
Yes,
a case
my lord.
wherein.
My lord, but what I'm trying to say here is that, lordship, that when it is very difficult or when there is minimal chance of conviction, the recourse of section 37 cannot be attracted. And at the cost of reputation, nothing was seized from me. And again, at the cost of reputation, the persons from whom the actual items were seized, they have already been enlarged on bail. They are at large on bail, my lord.
Yes, Mr.
Lordship, with regard to the technical aspect, Lordship, since the case diary as well as the lower case record is there. Lordship, but as far as the person accused is concerned, Lordship, in fact, they have approached on various occasions by filing a bail application before the lower court. However, that was rejected.
Before this court or where?
Before the lower court, Lordship.
Acha.
On medical ground. And here they have
On
approached
medical ground.
Lordship.
Ah.
And that was rejected, and here they have approached this before this honorable court on parity, Lordship. However, that was also been rejected. There is a prima facie against the said accused under section 21C. And Lordship, Lordship is well aware that it is a commercial quantity, Lordship, and therefore the rigor of section 37, Lordship, of the MDPS is attracted, Lordship. And Lordship, however, Lordship, at this stage, Lordship, this is Lordship, as far as the order dated, the bail application 25/2025, there is a clear indication, direction by this honorable court saying that the trial court should expedite a trial.
Where is the order?
Lordship, which is a page relevant portion is at page 65, Lordship, of the bail application, Lordship.
65.
65, Lordship.
So his bail application was earlier rejected by this court.
Earlier
Yes, my
rejected
lord.
by this.
Oh,
He
then
approached-
there is a provision. You cannot file this petition before this court. The bench who rejected your bail application, it has to be before that court only. What was the bench? I mean, who rejected this bail application, Justice?
You are in
60?
Lordship.
Page number 60?
Page 61. Page 61 would be.
Lordship, however, the
Oh,
grounds,
it cannot be, it cannot be. There's a
the
clear
ground is
order.
different, my lord.
Huh?
The grounds are different.
Huh?
The ground on which I have approached this
Oh,
court
no,
is
no,
different.
whatever the ground. It has to be before, it was Justice Longkumar, I think.
Yes, my lord.
It has to be before that court only. Otherwise, you cannot enter it. Why you have not, why yesterday also you could have put this place before this court only?
Lordship, in fact.
I have
Otherwise-
just
They have
requested the
approached
orders
this
and all.
honorable
It is a strict direction from the
Lordship.
High Court. Down the principle, this was notification that it cannot be listed before any other court except that
My
court.
lord, my lord. We were not aware of the notification.
Why?
Otherwise,
Why you are not aware of?
no, the notification.
Lordship, in fact, they approached this honorable court on technical issue, technical ground, Lordship.
Ah.
Because
No,
of
no,
that-
whatever the ground. That court who rejected the bail application, that has to be
My lord,
before
my
that
lord,
court, but at a
my lord.
particular court only.
My lord,
It was rejected by Justice Longkumar, it has to be before Justice Longkumar only.
my lord, my lord.
Before I just, you did not bring these things before us, na? And while applying your bail application also, the affidavit was also not there, na? There are clear direction, na? Otherwise you people
I have
will be,
annexed.
you people will be maybe choked by the High Court also, because these are the clear direction of the High Court.
My lord.
In fact, hearing the case heard, Mr. Swenso, the learned counsel for the
Otherwise,
petitioner, also heard Mr. Vijamu, the learned Swenso. After hearing the case at length, it was pointed out by Mr. Vijamu, the learned PP, that earlier bail application for the present petitioner was rejected by Justice Longkumar, White order dated
24/11/2025.
24/11/2025 in bail application number
25.
25/20.
25/2025. And in view of the notification of the Honorable, the High Court, as per the High Court notification, the matter is to be listed before the bench, which has already earlier rejected the bail application. List the matter accordingly before the appropriate bench.
My lord. Deeply obliged, my lord.
For order, item number 10.
The hearing at the length.
May I please, your ladyship? May I
Yes.
please?
Item 10, no?
Yes. Lordship, my seniors is in like in court number 1. can you, if this court can kindly accommodate this item at 2?
No, sorry. Otherwise, it was a fixed matter.
In fact, Lordship.
It was a fixed matter.
Then
Then what to do?
we'll,
Because this
we'll
is
try
also
to
my last item of my hearing. What was the IA for, in fact? IA was for?
IA was filed for vacation of the status quo. The status quo has been passed in the absence of the party.
Like my senior is ready. He's also here. My senior is ready, but however, I've been informed that his senior.
Isn't like, in fact, we can take up the, if your lordship
Who
can
though
kindly
will not be
accommodate,
here?
I'll call up my senior.
Just you can
Otherwise, the matter
try.
has
If
been
he is
dragging on
not
for some
dealing
time.
with, no, if he is not dealing with any other case, I don't think it will take much time for hearing.
Yes,
So
Ladyship.
you can just inform him.
Ladyship.
Just inform me if he is busy with another hearing, then it's okay. Or if it is not free, then for 10, 15 or 20 minutes hardly it will take. So just let's call it. And you are for the other side?
Yes, my lord.
Okay.
Yes, Your Ladyship.
So when this order was passed, in fact, the stay order,
7/11/25, ma'am.
7/11.
7/11/25.
It's a 7/11/25, the order was passed where the stay was there.
Status quo.
Oh, sorry, status quo was
Status
there.
quo. Yes, Your Ladyship.
Cases of how the status quo, what was the case, in fact?
Your Ladyship,
Briefly, yes.
Briefly,
No, just you, I'll just take.
very, Your Ladyship.
Yes.
So, Your Ladyship, there is an association called the Lotha Baptist Churches Association. So, this is an association, an umbrella organization of all the churches in the Lotha tribe. So, within the Lotha Baptist Churches Association, a dispute arose. Two groups came to claim to be representing the LBCA initially. I was one group, and another group was claiming to be the LBCA at that point of time. Between us, the dispute continued for some time, and ultimately, more or less, I was the only LBCA remaining. One LBCA was remaining. The persons who were representing the other group at that point of time, they became silent. So I began functioning effective from the month of July 2023. So the LBCA functions under an office which is designated as the Executive Secretary. So I began functioning as the Executive Secretary of the LBCA with effect from July 2023. I was put in office by the same persons who are now in the other group. A third LBCA came into the picture in the year 2025. 2 years down the line. 2 years down the line. And based on their application, Your Ladyship, they submitted an application to the state government saying that the renewal, it is a registered society, Your Ladyship. So it has to be renewed every 2 years. So they submitted a representation to the state government saying that the registration certificate should be given to them. And the registration certificate was given to them. That is how I am before this honorable court.
The registration certificate was given to them.
Was given to them. The LBCA which came into existence only in the year 2025, whereas I was there from 2023. So there were three LBCAs effectively. The first two groups which we were in dispute, one group became silent. This LBCA came into the picture only in the year 2025.
25.
Registration certificate was given to them.
Given to them.
Yes. And not only that, based on the allowance of the registration certificate to them, the district administration issued initially, Your Ladyship, so certain actions were taken under the Societies Registration Act. Actions to ascertain who is actually the LBCA. The disputing parties were summoned by the Registrar of Societies, and the office of the LBCA was locked on orders of the Home Department.
Okay.
That came to be challenged. And so this Honorable Court held, in the last writ petition held, that such orders were in excess of the Societies Registration Act. There is no such point in the Societies Registration Act. And any member who is aggrieved is at liberty to approach the competent forum. And the action of the state was set aside. The locking of the premises was set aside. The locked premises were not handed over to me. After the registration certificate was issued to them, the premises were unlocked The order which was...
Oh, acha, acha. It was unlocked.
Yes, the order which was set aside by the Sovereign Court, it was unlocked only at this point of time. And the keys handed over to them.
Acha.
That is, in a nutshell, that is the case. Now, considering the situation, Your Lordship, I asked for a stay of the registration certificate as an interim order. But the Honorable Court thought it appropriate that at this point of time, a status quo order would best suit the
So
circumstances.
suppose if the status quo order is there,
Yes,
in that case, status quo means the status quo. So it was unlocked,
yes,
the key was handed over
yes.
to them.
So what happened, my...
So now you are in,
Yes.
I mean, you are in there, I think.
Yes.
Now-
So there are two parts to this, Your Lordship. There is the LBCA office is in a locality called the Mission Compound, Wangkosum. So I was in occupation of that premises. So when I was in occupation of that premises, the office was locked.
So
But I
they
was-
now cannot enter that
They have
premise.
entered.
They have already entered.
They have entered.
No, entered because the key was handed over to them.
Yes. The key
So
was
now
handed
what
over.
is your problem?
Yes, here my problem
Suppose
is
if
that,
suppose status quo is also there, so you were in position, your key was already handed
Yes,
over.
Your
to
So,
them.
Your
Here's
Lordship, there's one more point. So the Mission Compound has many premises.
yes,
Acha.
So the residence of the executive secretary is also in the said premises. So I am the executive secretary of the LBCA. They claim to be the LBCA. They have their own executive secretary. I am still in the residential compound of the executive secretary.
that part where,
Office premises were unlocked and given to them. So I
Office
am
premises was? No?
of the office premises, not the residential compound, because I was already there. in
you
the
were there,
residential- Yes. So the office premises, the administrative block, and certain guest houses, the keys were unlocked. Those were unlocked and given to them. So as on date, I am in possession of the residential premises, and they are in possession of the residential block. So that is the position of status quo, Your Lordship. So how can that be of any harm to anyone, Your Lordship? I don't
So
see
therefore
why you should be filing an application for modification of the order.
therefore, Lordship, the case is that the occupation of the present ES, the executive secretary, the petitioner, is an illegal and forceful occupation because the rest of the premises is within our control and the registration itself is in our favor. And the second point is that there's non-jointer of parties in the present petition. Thereafter, the interim order was passed without hearing the parties, that is we, the private respondents.
Obviously,
therefore,
when the petition is moved,
this-
they are not represented.
Therefore, the status quo as of now has to be vacated. Otherwise, the illegal possession and occupation by the ES will still continue, whereas the registration has not been stayed, the order of the administration has not been stayed. It's just that he is illegally and forcefully been allowed to occupy the residence of the ES. Therefore, that part should not be kept in status quo. There should be no operation of status quo in the present case, unless and until the entire matter is heard in merit. That is my
precisely the point, Your Lordship. If there is no order of status quo, the situation will escalate between the two groups. And in the last proceeding before this Honorable Court, this Honorable Court came to the conclusion that there is malice in law on the part of the state respondents. I am in occupation, and yet the office was closed. This Honorable Court came to the conclusion the state should not interfere like that. And yet, now a third group, a group which was not a party to the previous proceedings, a group which came into existence only in the year 2025, a new group, the key has been given to them.
This group is a formation from the two rebel groups. They are outcome of these two rebel groups, Lordship.
And then
After a merger, this LBC, the new group came into
But
existence.
your petition for vacating of the stay order is that now illegally the ES is under that occupation,
Yes.
occupying that.
The rest is
premises.
within our
The
control.
rest is within your control or possession.
Yes, possession, yes.
Because the registration is in your favor and the key is also with you.
Yes.
But in spite of that, do you facing any difficulty now? What is your difficulty? What is your
Yes.
problem now?
My problem is that once the ES residence is vacated, the new incumbent ES will come to the field. He will have to administer the entire Wangkusang Mission Center.
That means you are saying that the new ES will be appointed by you, suppose, or who
No,
is
it's already there. It's
already there?
Yes.
He could not enter that that residence
Yes,
premises
Lordship.
because it is under the possession of the earlier area.
Yes.
So that's why you are saying that that is the quotient.
Yes, that's the problem.
So now there are two LBCAs, two associations, one which they claim to represent and one which I represent. So who is actually the real LBCA? That is the issue in this petition, Your Ladyship. And I am challenging the award of the registration to them. Everything else is a consequence, Your Ladyship. Everything else is a consequence. The
Now,
main challenge in this writ petition, Your Ladyship, is the award of the registration certificate, the renewal of the registration certificate to them. Everything else follows that, Your Ladyship. The point is very clear here for me, as far as I'm concerned, Your Ladyship. There were two LBCAs earlier. They were never a party to that. In fact, they were a part of my group when we were contesting with the other group. That group was silent. They put me in office. They elected me as the executive secretary in the year 2023. According to the constitution, Your Ladyship, I have a tenure of 5 years. Office bearers have a tenure of 2 years. The office bearers were just elected last year, in the end of last year, where they were also a party. Now, just because they don't like me, they have formed a rival LBCA. They have a game of musical chairs, Your Ladyship. Who has the majority? That kind of a strategy. That has come into the picture. Very unfortunate. Even in the church, the Gayaram philosophy has now been adopted, Your Ladyship. This is precisely what is happening. And this is totally unconstitutional. The only way I can be removed is through the process of the Constitution. And the Constitution very clearly says, if the ES is not competent, he can be removed. They're not resorting to that provision. They're just saying that they now represent the majority of the churches in the Lothar tribe. And therefore, they are the LBCA, which is wrong. That is my case, Your Ladyship. So I am saying, this third group which came into existence only recently, should not have been awarded the registration certificate by the state. That's my case.
Your case.
Yes,
that is
ma'am.
your case.
That's
Now,
my
this case is that the state was operating, which is, as per you, illegally he is occupying the premises and all. The new incumbent could not take up the charge and all. Though the registration certificate is still with you and the key is handed over.
Yes.
That much only, isn't it?
Yes, that's his case.
now therefore, the miscarriage of justice will only cause if the status quo is in operation. Otherwise, that should not be in operation. Because the fact that I'm also the ES who has the registration certificate and who has the mandate of almost 142 churches. Out of 146 churches, I was elected in that manner after a general resolution meeting. Secondly, the present incumbent, otherwise the illegal occupation by the ES, has to be vacated as per the order.
No. There is no order directing me to vacate, Your Ladyship. That is wrong. In fact, Your Ladyship, there is a section 144 CRPC order operating from 2022.
To prohibit
That
the
was
order.
violated. Unfortunately, Your Ladyship, in the first writ petition, in the last writ petition, there are three writ petitions in fact. The last writ petition, which was disposed of by the Honourable Mr. Justice Devashish Barua, this Honourable Court came to the clear conclusion that the state cannot resort to the provisions of the Societies Registration Act to take action against the disputing parties. If any member is aggrieved, go to the competing forum. And the state cannot resort to practices which are in fact malice in law. Malice in law how? At the instance of one of the parties, when I am in occupation of the mission compound, come and lock the office premises. I have been in occupation since 23, Your Ladyship. They have come in only recently, 25, and they are saying I am in illegal occupation. The state again has interfered, Your Ladyship. The state has interfered in the functioning of the LBCA and handed over the keys of the mission compound, the administrative block of the mission compound, illegally to the respondent number, the private respondent. That is my case, Your Ladyship.
Now, therefore, my Ladyship, if I may read out this part of the IA for clarity. That the applicant states that the aforesaid writ petition is not maintainable in the eye of law and is liable to be dismissed on this, by this honorable court in the threshold on the following grounds. Now, the point is that...
Grounds where? You are saying in IA?
Yes, IA.
No, then
My
it
IA.
will be, it
Therefore,
will come before this.
These are questions, series of maintainable ground raised in the affidavit in opposition. That
yes,
would be the,
that
that
has
would be
been raised. It
different
will be
aspect.
heard,
Now
yes.
here, my guess is that the status quo order should be vacated. There will be no miscarriage of justice. The ends of justice will be equity to both the parties, to all the parties. Otherwise, if the status quo is running, it will adversely affect the present respondents. Therefore, my humble submission is that the status quo as of 7/11/2025 should be vacated.
Just one last submission, Your Leadership. This is the judgment of the Honorable Justice Devasis Bura, the last judgment before this, that may be Bureau's leadership. The picture is very clear. And that's
No,
the
we are not hearing the entire case.
No, not the entire
The
case.
question is that there may be illegally, as per you, the registration was very illegal and key was also handed over because you were in position or you were in charge for this 2023. They simply get into the picture in 2005. These are the things you have submitted. So as per him also, there are some submissions why the instant writ petition is not applicable or not maintainable.
Not maintainable.
Not maintainable.
Can
So
I-
there are some grounds he brought.
Yes.
But I'm not on that. But the question is that why this status quo should be there or status quo should be vacated. That was mentioned.
Yes.
So I'll pass the order.
Very, very good. Much obliged.
Obliged.
May I please, my lord. Lordship, I may be,
No, I'm not going to entertain the case. What are you going to say? Once rejected by someone, it has to be before that court.
no, the Supreme Court.
No, not Supreme Court.
No.
Our High Court notification.
Yes, but that notification has been issued based on the direction passed by the Honorable Supreme Court. Now, Supreme Court has clarified certain things, Lordship. By order dated
Through online. You fix it tomorrow, through online you submit.
7/2/2025, my lord.
Through online you make a fixed date through online. We are not entertaining any
My
case.
lord, my lord, my lord, my lord.
Ask the registry to fix the matter tomorrow and
My lord,
or the
then
after
in-
tomorrow through online you can
My lord,
submit.
if that can kindly be reflected in today's order.
No,
to fix it,
appropriate bench I have submitted. You
through
can-
video conference on Friday, my lord. If that's possible, Friday. Tomorrow may be too sudden to make the arrangements, my lord.
Last order was there, no? So however considering that order, no? However considering the submission made by Learned Counsel for the petitioner, matter may be listed before the appropriate bench and that may be heard through virtual mode as it is stated that the bench is not available. It is stated court is not available. As it is submitted that the court is now in the বাকি না লাগে through virtual mode করে দিই accordingly considering the urgency of this case matter may be listed on Friday is 12th, no? 12th so and so the registry will do the needful. Okay.
I am deeply obliged, my lord.
I'll pass this order in the chamber. You come. Oh, there is a lot more dictation with you, then I'll pass the order with Borman. Borman is typing actually on CAB. Yesterday's CAB. That's why I'm giving you, in fact. He is typing the CAB. Yesterday's that matter. So it's just come to my chamber. I'll complete it within 10 to 15 minutes.
Deeply obliged.
खत्म है ना